Hello everybody and welcome. This video blog is part of my website, uslegalwriting.com, and you can reach it by just adding /blog to the website address. Not too long ago, I had a conversation with a small firm attorney out west. I'm in Maine, so pretty much everybody I talk to is out west. She was interested in hiring me to do some research and writing for a trial memo she had coming up. The main legal issue turned on a very precise understanding of a complex factual timetable. At one point in what by then had become a lengthy conversation, the attorney suggested that I should get in touch with her client directly, sort out the facts for myself. I appreciated her confidence in me. It's always nice to be trusted. But I declined to speak with the client. I did so because I think this is a recipe for trouble. Here's the problem. In most of the work I do, I'm not admitted to practice in the state where the hiring lawyer is located. And that was the case with my friend out west. In such situations, I don't function as a lawyer, at least as far as the hiring lawyer's client is concerned. Now, it's true that I'm a lawyer, and this is the reason why attorneys around the U.S. hire me to work for them. But that doesn't turn me into a lawyer in the eyes of the Bar Association or the Supreme Court, where the matter happens to be pending. To them, I'm simply a provider of legal services, more of a glorified paralegal. And this is as it should be. I work for the hiring lawyer, not that lawyer's client. The hiring lawyer, of course, is free to ask me for legal advice. This happens all the time. Why hire somebody with 30 years of experience practicing law if you're not going to take advantage of some of that experience? But that opportunity is not open to that lawyer's client. The minute I give any advice to that client, the minute that client interprets anything I say or anything I don't say as advice, I am open to a charge that I'm practicing law in that state without a license. Now, to my ear, this has a really bad ring. I have no interest at all in taking this risk. Direct contact between me and the lawyer's client is dangerous for me and even more dangerous for the hiring lawyer, who has an obligation to prevent me from engaging locally in the unauthorized practice of law. Why is this even more dangerous for the hiring lawyer? Because he or she is subject to the jurisdiction of the legal practice authority in that state, and I'm not. So as much as I wanted to be helpful and work through the case in the most efficient way, I had to decline to speak with my friend's client. Instead, I asked her to talk with the client, clear up the factual ambiguity, and get back to me. It might not have been the most efficient way to proceed in that particular case, but it was the safest.